Comes on regarding reasonable attorney's fees request, and I've reviewed all of the materials that have been provided. Mr. Thomas, how much are you asking? The one thing I did not see was what you're requesting for today's hearing and your preparation for today's hearing.
I haven't written those hours yet, Your Honor. I didn't know how long the hearing was going to last today, and I had to do something else last night in preparation for this case too. So I'm sorry, I don't have those available to me today.
Well, then how would you like the court to be able to handle that portion of your request?
My hope is that since Lewis County hasn't seen the number either, that I can work it out with Lewis County since they're willing to, since they already said that they'd be willing to pay some money for it. And then if not, I would just propose that we just have another hearing about this in 2 or 3 weeks, if we're not able to resolve it.
Well, my only concern is, and it's more a concern for, in many ways, the two of you, and somewhat for the court, but it would seem that those hours would be able to be contemplated by the conclusion of today's hearing, because it would make sense to be able to get it all resolved at one time.
I can put something in writing for Your Honor if that would please the court.
Well, as an officer of the court, I certainly, I've seen your request up to this point, so I'm happy to hear what that request is what I'm saying.
Okay.
Okay.
Thank you, Your Honor.
You're welcome. So, Lewis County had filed a response, and then the plaintiffs had filed a reply to that. I'll give you each a short opportunity because I've reviewed everything. So, Mr. Thomas, I'll hear first from you, then I'll hear from Mr. Eisen.
Thank you, Your Honor. We're here today because Lewis County violated the Public Records Act. Lewis County, through its own admission in the response brief for this hearing today, says that they didn't prevail on any issue in front of this court. However, Lewis County wants to reduce plaintiffs' attorney's fees by 33%, and they lost on every single issue in front of this court. If Lewis County spent more time, if they had settled this earlier and they took reasonable steps, we probably wouldn't be here right now. But Lewis County is inherently unreasonable in this litigation, and that's why we're here today. When deciding attorney's fees, this court needs to consider the purpose and the intent of the Public Records Act. The purpose and the intent of the Public Records Act is found in RCW.
And again, I will tell you, I've reviewed all of your materials, not only for this hearing, but the other case. So I'm very aware of that. Anything that you want to highlight in particular that you think would be helpful for the court? Because I've reviewed everything.
Yeah, so I'll just make a quick summary then. This court needs to not narrowly construe attorney's fees. It needs to be liberally interpreted pursuant to the statute. There's binding case law. Actually, it's very well established. It's, what, 25 or 30 years worth of case law saying that, which is still good case law, saying that strict enforcement of fines and fees helps enforce the Public Records Act, and also that the liberal construction of attorney's fees derives from RCW 4256.030. And then the other thing I'd like to point this court's attention to is that Lewis County didn't offer any evidence for any of their suggestions. They come in here and they make naked assertions to this court. Mr. Eisenberg documented his hours in a motion for sanctions against me earlier in this case. And he's criticizing the reasonableness of the hours, but both in Washington State from the Division II Court of Appeals opinion that was cited in the response brief, or in the, I believe it was the opening brief and the reply brief from 2012, they say that the best evidence to combat the reasonableness of the attorney's fees is for the opposing counsel to submit its own attorney's fees. And in fact, I buttress this case law with FOIA case law. And I believe there's 3 or 4 cases from the District of Columbia federal court saying the same thing. And Mr. Eisenberg clearly did keep track of his hours in this case, But Mr. Eisenberg doesn't submit any evidence to this court. He wants this court to take him based upon his word and based upon his conclusory statements. And that's not appropriate. This court needs to take an active job. Plaintiff fulfilled their burden by submitting a spreadsheet, by submitting a declaration, things that in case law say that you need to do because you just can't make assertions about attorney's fees. And Lewis County says that plaintiff is just making assertions, but comes back and only makes assertions of their own and offers no evidence to substantiate their position. And so plaintiff just asked this court, in order to rule on the evidence today, this court needs to use a preponderance of the evidence because attorney's fees are findings of fact and conclusion of law. And this court needs to look at the facts, and the only facts today are the evidence that plaintiffs presented. Thank you.
Thank you, Mr. Thomas. Mr. Eisenberg.
Thank you. In order to not waste the court's time, there's two things I'd like to touch on. One is that in the reply brief, Mr. Thomas made a much bigger argument on liberal construction, so I wanted to respond to that briefly. Both parties cite Berryman v. Metcalf as part of binding authority for this type of thing. I urge Your Honor to take a look at that case again. That is a liberal construction case, just like the PRA case, and nevertheless, the court engages in an extensive analysis of what's called the Fetzer case, which is F-E-T-Z-E-R. And it deals with a situation in which the court believes that the amount of hours that prevailing counsel has billed are more than reasonable. And it makes clear that even in a liberal construction case, that Your Honor is empowered to go through and decide which of those hours is reasonably spent, just as you did in the previous case. That analysis, I think, is within your discretion. I ask you to employ it again in this matter. The other thing that I'd like to touch on is attorney's fees for this motion. It just, in the interest of efficiency and fairness, I would much prefer that Your Honor rule on a reasonable attorney's fee for this motion, just so that it can be done. Because the thing is, if we negotiate about it, if we set another hearing, those are all more attorney's fees that Lewis County must pay at least a portion of. And I do think that there's been enough evidence for Your Honor to set a fee for this hearing. I request that you do so. In doing that, I mean, I don't mean to be rude, but I have to point out that there were things that Your Honor just decided in a very similar case that Mr. Thomas re-argued for this case, like drive time, some of his hours, multiplier. And so I do think that, that again, setting a reasonable amount of hours for this hearing that does not match what he would have billed for the hearing is an appropriate thing to do. You've seen my analysis, and the amount I propose is about $40,000, which is similar in many ways to what you awarded in the other case. It also is similar in terms of its relation to the underlying penalty, which is only about $20,000. Again, Berryman makes clear that considering the proportionality of the attorney's fees to the underlying amount is proper. Thank you.
Your Honor, if I may, I just want to make one quick objection. Lewis County did not argue the liberal construction of the attorney's fees. That was in plaintiff's opening motion, and in the reply, plaintiff pointed out that there was no mention of argument by Lewis County in their response brief about the liberal construction of attorney's fees, so they waived this argument for today, and this shouldn't be considered by this court. Thank you.
You're welcome. Well, the court does have a duty, and we discussed this before, Mr. Thomas and Mr. Eisenberg. The court has a duty to award reasonable attorney's fees, and there were some things that the court would note from the hearing we recently had in another case. Lewis County did not argue this time regarding the rate that Mr. Thomas would be compensated at. The court will compensate Mr. Thomas at his requested rate of $250 per hour. And the court does factor into that the fact that there is an expectation that an attorney will be able to efficiently work through issues based upon his or her level of expertise. And that's part of what the court wants to determine whether the hours requested are reasonable considering the work that was done, the complexity of the work, and the experience of the attorney. The issue about travel time, Mr. Thomas raised this issue again. The court is not allowing travel time to be compensable. That is not, except in very limited circumstances, something that would be done. Those factors are not present, and I'm relying upon Roberson versus Perez, 123 Washington Appellate, 320, 2004 Court of Appeals case. So the travel time will not be compensated. And that was 10.2 hours that Mr. Thomas had requested. That's not supported by law. Mr. Thomas also requested a multiplier. That multiplier clearly, as our state Supreme Court has repeatedly said, and I told these parties very recently, that is a rare circumstance when there's a multiplier. And I do not find that those factors support, in this case, a multiplier being awarded. And so the multiplier will not be awarded again. Now, and I want to say to Mr. Thomas, again, I appreciate that you have put forth your spreadsheet. That is a appropriate way to put forth your hours, and it is helpful to the court. And I think it's probably was helpful to Mr. Eisenberg as well. And I'll just say again, Mr. Thomas, I know there's been a lot of rhetoric. I find, again, that both you and Mr. Eisenberg have worked professionally on this case. I think you're both doing your jobs, and the rhetoric is not helpful to this court at all. What is helpful to the court is legal argument, and that being done in a way that's courteous to the other side, respectful to the court, and that's my expectation. So regarding, and probably the easiest way to go through this is to look at some of the objections that were made by Lewis County. And specifically, Lewis County had objected with the cost and fees, the attorney's fees that were requested by Mr. Thomas in lines 4 through 7. Those dealt with the factual research and the drafting of the complaint. I disagree with Lewis County. I'm awarding those fees as requested by Mr. Thomas. I think they are reasonable. Entry number 9, Lewis County, again, disagreed and thought the amount of time Mr. Thomas spent reviewing Lewis County's answer to the complaint was unreasonable. The court will note Mr. Thomas requested 2.4 hours. I do not find that to be unreasonable, and that will also be granted. Docket lines 11 and 12 were requests by Mr. Thomas to have 14 hours awarded for time reviewing responsive documents produced to the Public Records Act. The court does not find that this was productive time. It's also difficult for the court to tell exactly how this tied into the litigation. It does not appear to be supported, and the court will award 0 hours on that requested entry. On docket line 13, Mr. Thomas had requested 2.4 hours for reviewing Court Rule GR 31.1. The court will award 1 hour. That appears to be a reasonable amount of time for Mr. Thomas, for someone with his experience, and the fact that that's not a particularly complex rule. Entry 16 was the time necessary to file the complaint and summons. The court finds Mr. Thomas's requested entry appropriate and does not, will not reduce that pursuant to the request of Lewis County. Docket lines 25 and 26 dealt with what's entitled Research Case Law Retroactive Statute. Mr. Thomas had requested 10.9 hours, excuse me, for those two entries. The court does not find that that amount is supported by the litigation in this case. The court will award zero time for that. It did not appear to be time that was used in this litigation, nor was it productive to the issues as originally essentially determined. Docket line 46 dealt with reviewing Lewis County request for discovery. Lewis County objected. The court finds Mr. Thomas's request for 1.4 hours to be reasonable. Lines 47 and 48 were a total of 9 hours dealing with researching a response to the Lewis County request for disclosure and drafting a response to that same request for disclosure. The court again will grant Mr. Thomas the time that he requested. Line docket entry 59 was drafting discovery request for Lewis County. Lewis County objected to that 3.1 hours requested. The court finds that the time requested by Mr. Thomas was reasonable and will grant that requested time. Lines 84, 85, and 86 were 14.8 hours that Mr. Thomas had requested regarding replying to a merits brief. And Lewis County had objected to that, finding that much of it was duplicative from efforts that had been spent on the opening brief. The court concurs looking through those documents, and the court will award 8 hours to Mr. Thomas as opposed to the 14.8 hours he had requested. Docket lines 92, 93, and 95 were a total of 13.7 hours. These were dealing with Mr. Thomas's motion, response to Lewis County's motion to continue and to reconsider. The court, reviewing those, again found many of the issues to be duplicative of other pleadings, and the court will award only 7.5 hours for those entries. Docket line 97 was one of the hearings. Mr. Thomas indicated 4.3 hours, which clearly was not the length of time of that hearing. The court will award 1.5 hours, as that was still generous, but would be an accurate, a more accurate record of the amount of time for that hearing. Docket 118. Docket 118 was a request from Mr. Thomas regarding researching Freedom of Information Act exemption attorney-client privilege. That is non-productive time to the litigation in this case, and the court will not award any hours for that time. That goes on to 119 as well. The court will award no hours for that time requested. Then the court looked at interest regarding the emails and the communication and attempts to draft the CR2A agreement that Mr. Thomas and Mr. Eisenberg ultimately presented to the court. Lewis County objected to the amount of time requested by Mr. Thomas. It's starting at docket entries 127, 129 through 134. Reviewing those issues, and the court finds that Mr. Thomas's requested time of 6.5 hours for the total of those entries is reasonable, and the court will order that as well. So my calculations, therefore, were Mr. Thomas had requested $59,875 for his attorney's fees. The court had removed the driving time, which was 10.2 hours. That's reducing his request $2,550. The court also had removed, as we went through the hearing and I went through those docket entries, the court had removed I'll just give the totals for the entries that I went through with the parties. The court had removed 14, 1.4, 10.9, 6.8, 6.2, 2.8, and 8.4 hours. That put the total attorney's fees to date at $44,700. Mr. Thomas, I'd hear from you now about what you're requesting for this particular hearing for your attorney's fees.
Does this court want me to give an amount now, or does this court?
I'll accept your word as an officer of the court. Again, I'm looking for the reasonable amount of time to prepare for this hearing and for you being here today.
Okay, I spent 6 hours on the reply brief. I spent 4 hours last night researching this case based upon a conversation that Mr. Eisenberg and I had by email, which was about our CR2A agreement and the validity of the CR2A agreement. And then I spent however much time in court today.
Thank you. Mr. Eisenberg, do you have any objection that as the court computes it, that would be 9 hours that Mr. Thomas is requesting?
I feel it's my duty to at least partially object to the research last night. I believe, I'm not sure, that Mr. Thomas is referring to an email concerning Lewis County's appeal of the underlying merits order, which was recently filed. And to me, that seems like research that's related to the coming appeal as opposed to this hearing, and could be addressed as attorney's fees on appeal. So I guess I would request that Your Honor give him, for example, 1 hour of that research as opposed to all of 4 hours, because of that's overlap. Thank you.
You're welcome. The court is prepared to order 4 hours for the briefing, and that's based upon my review of the briefing for an attorney of Mr. Thomas's experience and capabilities. 4 hours would be appropriate. 1 hour will be awarded for research. 1 hour will be awarded for today's hearing. So there'll be 6 additional hours, which comes to an additional $1,500 of attorney's fees. Does either party have any clarifying questions?
No, Your Honor.
I have nothing.
Very well. Then I trust the parties will be able to put together a appropriate order.
Thank you.
You're welcome.